Hello there, I'm Drew Underwood. I'm Senior Safety Consultant here at HCS Safety, and just wanted to give you a bit of a update on the law and either what has changed over the last 12 months or the big changes that we're looking forward to. So it's been a relatively quiet one. The HSE is basically only making absolutely necessary changes to law at this moment. As you can imagine, they've been very busy with COVID and the various requirements that have happened to them there. So it's been a relatively simple one for us to try and deal with. What I wanted to look at is the two that have already been brought in during the year and one that's on the horizon and things which are going to have to be at least looked into for a lot of companies over the next 2 to 3 years as we wait for it to be fully introduced. So the first set of law that is already here, only very recent, it came in on the 6th of April this year, is the amendment to the PPE regs. Now, the amendment here doesn't actually amend a huge amount in terms of the duties of employers to provide PPE. What it actually does is it just expands out the number and the types of groups that you have to provide PPE for. Now, forgive me for getting a bit technical here, but we've got two different definitions of worker that we have to look at here. So you've got what's known as the Lim A workers. So these are people with a contract of employment. That could either be a verbal contract or a written contract, who are very much considered your employees. They are, as they always have been, entitled to all the PPE they need for their work free of charge. Absolutely nothing has changed for them. The difference we have now is that they've also included a second group of workers which are referred to as Lim B workers. So a Lim B worker is slightly different. They usually work on what's known as a contract for service. So these are very much more the sort of subcontracted, almost self-employed workers that you might have, particularly within construction environments and manufacturing environments, who work on a slightly more casual basis, but are not running their own company as, say, a limited bona fide subcontractor are. Now, for them, they haven't previously been covered under these PPE regulations. They now are. So employers are now expected, whenever they have one of these Lim B sort of self-employed type workers, to ensure that they are also provided with adequate PPE in order to control risk to them while they're at work. Now, for a lot of companies, they've always taken that approach anyway. But for other companies, this is going to make a major difference now that you are responsible for providing that as well. It does only cover PPE, it's not extended out to any of the other requirements. So PPE and the training required to use it is covered. Other training, other responsibilities haven't changed at all. The next law that's also come in during the last 12 months is the Fire Safety Act. Now, again, a relatively minor amendment to a law on this one. In this case, what it amends is the Regulatory Reform Fire Safety Order, and once again, what it's amending is expanding out its scope, making one law that we've already got cover some areas that it didn't previously cover. Principally in this case, what we've done is we've taken the requirements which have always existed for communal areas of buildings and expanded them out. So we now have to consider areas like the external finishes of buildings, obviously particularly relevant to Grenfell, like balconies, windows, covering and cladding systems, and we have to include those into our fire risk assessment. The other change is in the internal areas, where previously people were only required to generally consider the communal areas of their building. We're now being asked to consider the join between a communal and a domestic area, specifically the doors and windows and the door frame sets that they are attached to. Again, this was a major area that was identified as failing in Grenfell. The law has been updated to make sure that that loophole is closed and that responsible people are aware of what the hazards are and aware that those doors, which are integral to the fire safety of the building, are to a necessary standard. The final law to talk about is a law which is actually quite some way off yet. We honestly couldn't say at this point exactly when it's likely to come in, and that is the Building Safety Act, or the Building Safety Bill as it is at the moment. At the moment, this is still being kicked around Parliament. There have been some recent amendments made to the structure and how they intend for this to work. But this is really our major law update following the Grenfell Tower disaster of 2017. So the plan for the law is that it's going to cover high risk buildings, which they define as buildings over 18 metres to the top floor or buildings over 6 stories in total height, which includes residential areas anywhere where someone's staying overnight, student accommodation. It's that sort that we are considering to be a high risk building. Now, for many, many projects, this is not going to have a huge amount of relevance to them. For those that it does apply to, it's going to be a huge, huge change. What they've done is almost introduce a second CDM design, which is going to cover the fire safety of a building. So it's going to be very similar to CDM in the sense that there will be gateways. You'll have to pass a particular gateway with documents and sign-offs at various points, working all the way from concept and design through to project construction and handover of that building to a client at the end. So there's going to be a lot more responsibility to try and deal with that. They are bringing in a new role that's going to be the accountable person, and they're going to be requiring that buildings have a safety case done on them, which means that there will have to be a written document considering all the hazards. As I said, this is going to be some way off yet. We don't really know exactly what the form is going to be at this stage. All we really have are these headlines for it. But it is one that we need to be aware of because it's going to change major parts of the industry in a major way at some point. That's all we have in terms of a legislation update. So thank you very much for listening, and I hope this has been useful for you.